Okay, good afternoon, everyone. I'm Bob Brownice, a professor of law here and co-director of the Ethical Tech Initiative at GW, and I'd like to welcome you to this conference on protecting reproductive data privacy after Dobbs. Both those of you who are in the room, and I think this is the largest crowd I've seen in about 3 years, and those of you who are joining us for the webinar. It is my great honor and pleasure to introduce the Dean of the George Washington University Law School, Dana Bowen Matthew. Dean Matthew is not only doing an amazing job leading this law school, but she's also an internationally renowned scholar in the area of health law and particularly the inequities of our healthcare system. So she's uniquely qualified to inaugurate this conference. I welcome to the podium Dean Matthew.
What a pleasure, what an honor. I am also so excited to see this room full, not only because it is so good to see people, human beings on campus again, but also because this is an important event. And I'm grateful to my colleagues for gathering and convening us to have the discussion that will follow. As you heard, this is an event that I expect will change not only hearts and minds, but also has the potential to change law and life in the real world. This is a discussion on protection or protecting reproductive data privacy, one of the most pressing challenges of our time. And as you may know, doing that kind of work, dealing with the most pressing challenges of our time, is core to our brand and our strategic plan. I'd like to begin by extending first a very warm welcome to our distinguished keynote speaker, Congressman Sara Jacobs. Thank you for being here, and to the remarkable panel of experts on digital privacy and reproductive justice who have assembled here at GW Law at this time for this discussion. Today's roundtable is a shining example of the important work of ethical tech at GW. Now, if you don't know already, this was established in 2020 by Professors Bob Brownice and Dawn Nunziato. It was established with a generous grant from the New America Foundation and with a lot of sweat equity from our faculty members, Bob Brownice and Dawn Nunziato. Our school is proud to host this important interdisciplinary initiative, which was designed to develop solutions to pressing problems that involve information privacy, content integrity, and algorithmic bias. This is a widely discussed issue and will require solutions for the widely deployed digital technologies that the world is facing today. I would also like to congratulate our amazing third-year student, Maya Arigala. Arigala, have I pronounced that correctly? Thank you. Maya founded and heads up our recently established Reproductive Data Privacy Initiative, which focuses on critical data privacy and content integrity issues related to abortion post-Dobbs. This year, Maya will be working on a public education guide on the topic, and she hopes to continue working in the critical field after graduation. So thank you, Maya, for your initiative and leading the way in this important work and important roundtable. You definitely make us proud. Now, next, let me take a moment to thank the co-directors and co-founders of Ethical Tech at GW. These are also leading lights in the field. As I've said, Professor Dawn Nunziato, the William Wallace Kirkpatrick Research Professor of Law at GW, and Professor Bob Brownice, the Michael J. McKinney Professor of Intellectual Property. But I want to tell you a little bit about the work of Ethical Tech so that you'll know not just their titles and the fact that they founded this entity, but what it does. The Institute partnered with researchers to develop interventions to combat misinformation online and to combat COVID misinformation, particularly impacting communities of color. Also, it hosted 4 distinguished visiting technologists who developed access to justice technology for disadvantaged communities, and it hosted several roundtables and career panels with these experts. Ethical Tech at GW also partnered with the DC Department of Corrections to provide paralegal instruction to incarcerated persons and to offer this instruction via virtual platforms throughout the Bureau of Prisons system, which is frankly amazing. It also partnered with the Access to Justice Tech Fellows Program to sponsor summer fellowships for GW Law students who benefit marginalized communities. So you have a lot of ground to cover, but I just want to take a pause for a second and just acknowledge the significance of taking the resources of the Academy, of the Legal Academy in particular, and taking them into communities to make a real, on-the-ground, impactful difference in people's lives and solving major problems. I want to applaud you and Ethical Tech at GW for that kind of work. That's what we should be about at GW Law. Professor Nunziato, in her own right, is an internationally recognized expert in free speech and internet, whose research focuses on content regulation, content integrity, and information privacy on social media platforms. I'm introducing her now because I'm going to pass the mic to Professor Nunziato. Before I do, I want to say, if you don't know, she also serves as the chair of TikTok's Content Advisory Council and lectures widely around the world on issues involving content regulation and freedom of expression on the internet. Professor Nunziato is the author of the widely acclaimed book, Virtual Freedom, Net Neutrality, and Free Speech in the Internet Age, which has been published in several languages. Ladies and gentlemen, it's my pleasure to introduce and ask to the podium Professor Nunziato.
Thank you, Dean, for that very warm welcome introduction. It is now my great honor to introduce to you Congresswoman Sara Jacobs. Congresswoman Jacobs serves as the United States representative for California's 53rd Congressional District, which is centered in the San Diego area. She serves as the freshman representative to the House Democratic Steering and Policy Committee, and she sits on the House Committee on Foreign Affairs, the House Armed Services Committee, and the House Select Committee on Economic Disparity and Fairness in Growth. Congresswoman Jacobs founded and serves as the founding director of San Diego for Every Child, a coalition dedicated to ending the experience of child poverty in San Diego County. She was also the founding CEO of Project Connect, an international education nonprofit dedicated to connecting students around the world to the internet. Most significantly, for our present purposes, Congresswoman Jacobs recently introduced legislation entitled the My Body, My Data Act, which would create a new national standard to protect personal, reproductive, and sexual health data. This legislation has received the support and co-sponsorship now of over 100 representatives in the House, and has also received the support of 13 senators. The day before Roe v. Wade was overturned this summer, in her speech introducing the act on the House floor, Congresswoman Jacobs said, and I quote, "It is unconscionable that our personal reproductive information could be sold to the highest bidder and weaponized against us, and especially against low-income people and people of color who would be most impacted if Roe is overturned." Of course, that if Roe is overturned turned out to be overturned the following day. In her speech, the Congresswoman also said that when the Dobbs draft decision was leaked, quote, "I knew we couldn't just wait for Roe to be overturned, so I got to work." We are so grateful that the Congresswoman got to work on this critical matter, and we look forward to hearing from her about her work on this critical matter. GW Law and Ethical Tech at GW are truly honored to be hosting Congresswoman Jacobs today. Please join me in welcoming her.
Thank you so much, Professor, Dean, Maya. We're going to put you to work. I got some ideas on what your initiative could be working on. And thank you all so much for having me here today. This conversation couldn't be more important, and it couldn't be more important to be having right now. Because when the Supreme Court threw out nearly 50 years of precedent and the constitutional right to an abortion, I don't know about many of you, but I was so angry I was literally shaking. Because for me, like for many of you, this is a deeply personal issue. As a young woman, reproductive health care is my health care. In fact, when I was your age, that was pretty much the only doctor I ever went to. And I get so frustrated when some of my colleagues say this is a side issue or a distraction from the things we need to be talking about. Because I'm a 33-year-old woman. Basically, every conversation I have with my friends is about babies, who's having them, who's had them, who wants to have them, who doesn't. And that's true for millions of Americans across this country. Reproductive health care is a kitchen table issue. Decisions about if, when, how to have a family, they've changed the trajectory of your entire life, and no one takes these decisions lightly. These decisions are serious and deeply personal, and they belong to individuals, to families. They don't belong to the Supreme Court or government officials. And since the Supreme Court struck down Roe, Republican-controlled state legislatures have been in a frenzy, restricting and banning abortion access across the country. I'm pretty creative, and even I couldn't think up all the crazy things they're trying to do right now. As a result, more than 1 in 3 women has lost most access to abortion. But since this decision leaked, we didn't sit around, and as the professor said, we got right to work. So in the House, we've already passed the Women's Health Protection Act, the legislation to codify the right to an abortion, twice. I'm so proud to be an original co-sponsor of that bill and to have co-led the introduction of the Right to Contraception Act, which also passed the House in July. But as we're here to talk about, we know that the post-Roe era isn't going to look like the pre-Roe era. And in some ways, that's a good thing. We have a lot more tools at our disposal now. We're not talking about coat hangers and back alleys. We're talking about medication abortion and traveling across state lines. But in the time since Roe was decided, we have created a vast digital surveillance system, one that can be used against people seeking abortions and those trying to help them. This isn't the same fight our mothers and our grandmothers fought. And that's why we need strong privacy protections, especially for people in states that are criminalizing abortion. And that's why I introduced the My Body, My Data Act. In the days immediately after the Dobbs decision leaked, I started hearing from friends and constituents panicked that their personal information could fall into the wrong hands and be used against them, asking me if they needed to delete their period and fertility tracking apps. We saw trending videos on TikTok showing women and LGBTQ plus folks rushing to delete the apps and encouraging others to do the same. I use a period tracking app myself, I get it. Our data in 2022 can leave us vulnerable. And it shouldn't be on each of us individually to try and figure out what we need to do to keep ourselves protected. And while some of these threats existed long before the Supreme Court overturned Roe, especially for low-income pregnant people of color, the risks are so much greater now. And apps are just one of the places we're at risk. We leave sensitive medical and location information behind in online purchasing history, in browser searches. As a millennial, I've lived most of my life online. And I'll be honest, despite being a very informed user, I've been guilty of scrolling down to the bottom of the terms of service agreement or the cookie permissions, not reading the fine print and just clicking yes. And I'm sure it's not surprising to you all. At 33 years old, I'm one of the youngest members of Congress and one of the few women of reproductive age. And when I was giving that floor speech, talking about the need for the My Body, My Data Act, I became the first person in 35 years, probably ever, but they've been tracking it since in 35 years, to talk about my period in a speech on the House floor. And when I went to talk to some of my colleagues about the need for this legislation, man, you have never seen grown men squirm like that. I mean, I'll tell you, both sides of the aisle. Most of my colleagues don't even know that women track their periods, let alone that period tracking apps exist or how they work, or even how data in general works. And how our data is being used has frightening implications in the post-Roe era, where our reproductive health information can be sold to the highest bidder and weaponized against us. If you're Googling how to obtain an abortion for yourself or a friend, if you're ordering abortion pills online, if you're using Uber to travel to an abortion appointment, none of that is currently protected. And just last month, we saw police obtain Facebook messages between a mother and a daughter in Nebraska as part of an investigation into an abortion that was illegal under their state law. And this is just the beginning. Republican officials, prosecutors, state attorneys general have shown no end of creativity in figuring out new ways to target abortion patients and providers. And that's why it's so important to create a new national standard to protect personal reproductive and sexual health data, like what's in period and fertility tracking apps, Google searches, location data, and more. Right now, there are almost no federal protections for this data and no federal laws regulating the data broker industry. Under my bill, the My Body, My Data Act, companies and nonprofits can only collect and retain and disclose data that is strictly needed to provide a requested service. You can ask for your data to be deleted at any time, they can't sell it, and they can only share it with your express written consent. The bill gives the FTC rulemaking and enforcement authority, and importantly, it also has a strong private right of action, giving individuals the power to sue if they think their data is being misused in any way. And these strong enforcement standards are critical so that we can take our power back to ensure that consumers are the ones in control of our own private information, our digital selves, and our own bodies. The bill also has a state non-preemption clause to protect existing privacy laws and future innovations in states like mine, California. And I'm so proud that, as was said, the bill has over 100 House members and that Senators Hirono and Wyden are leading the companion bill in the Senate. And I'm also grateful for all of the work that so many other advocates and groups have done to help us on this bill, including India, McKinney, and the Electronic Frontier Foundation, who were instrumental in helping us figure out the best way to craft this bill, alongside reproductive rights organizations like Planned Parenthood and NARAL. And look, it's great that some of these companies have already voluntarily decided to do the right thing, but we can't rely on the goodwill of companies. And let me tell you, most of these companies don't want to be the ones to have to make these decisions either. It's the government's responsibility to step in and step up to create a federal standard for protecting this information, lifting the burden both from businesses and from individuals. And I know some people here might not agree with this, but the answer can't just be, don't use an app, delete it, don't use the internet. These are important services that many, many people use for their lives. And while right now, that might be an important step to protect people in Republican-controlled states where governments are taking advantage in this moment, but it can't be the long-term answer. It is government's job to regulate these technologies and tools so that people can use them and they can have the protections and the privacy that they need. And look, my bill won't solve all of the problems. We need so many different approaches to protect data privacy post-Dobbs and frankly, in general. That's why I've also been leading on digital privacy with my colleagues to hold tech companies and data brokers accountable. In May, under Senator Wyden's leadership, I joined more than 40 of my Senate and House colleagues to push Google to stop collecting and retaining location information so that we can prevent prosecutors from using that information to identify people obtaining abortions. Along with Senators Wyden, Warren, and Booker, I also pushed the FTC to look into Google and Apple's unfair and deceptive data privacy practices. These tech companies actually design advertising-specific tracking IDs into their mobile operating systems, which data brokers, apps, and developers can use to collect, track, and sell information linked to specific consumers, including location and search history. Apps source the data, then sell it to the data broker companies that turn around and sell it to advertisers, hedge funds, other data brokers, law enforcement, and governments all around the world. And even though Apple and Google allow consumers to opt out of tracking, that's putting the onus on consumers, not the operators, which we know is just not an effective way to keep people safe. In July, I joined Representatives Carolyn Maloney and Raja Krishnamurthy, leaders of the Health Oversight Committee, in an official committee probe requesting the information and documents regarding the collection and sale of personal reproductive health data from top data broker companies and popular health apps. A study from earlier this year found that 87% of the 23 most popular women's health apps, including reproductive health apps, shared user data with third parties, yet barely over 50% of them requested consent from their users. Many people think that HIPAA protections applies to all health information, but sadly it doesn't. It only applies to information between you and your healthcare provider. So while we work to pass consumer privacy legislation, we also need to close loopholes in our privacy when we visit a doctor or other medical professional. And just recently, I co-led a letter calling on HHS to strengthen the HIPAA privacy rule, and I'm working with my colleagues to determine what additional congressional action may be needed. So what all of this tells you is that These issues are clearly complicated, and there's a lot of work we're going to have to do. But what it all boils down to is dignity. The dignity to live full lives online without second-guessing Google searches or downloading an app. The dignity to own our own health information and not have it treated like a commodity that's bought and sold for pennies, or even worse, used against us in a court of law. This is about dignity as full autonomous beings to make decisions about our own bodies without having to ask government for permission. So we're not going to go back silently to our pre-Roe rights. We won't do what we're told and accept this. This is time for justifiable outrage that we turn into action. This is time for new ideas, for marching, for organizing, for mobilizing, for voting, for running for office, even if that's something you never thought you would have considered before. And I'm so grateful to all of you for taking the time today to think about what else we might need to be doing, because it's going to take all of us to make sure that we are putting protections in place, to make sure that while we in Congress are working to make the access to abortion the law of the land again, that we are doing everything we can to protect the people in states who are currently preventing it. And it's going to take all of us working together to make sure that we are doing what we need to do. So I'm so thankful to work with you all on these important issues. I'm so thankful for you all for coming here together today to think more about this. And I'm so grateful again for you all for championing digital privacy and civil liberties, and most importantly, pushing for solutions. Thank you so much. It's an honor to be doing this work alongside you. Can we have our panelists come up and do this? Thank you. So thanks so much, Representative Jacobs, for that amazing keynote. Now we're going to transition to the panel portion of the event. So joining us in person, we have India McKinney, the Director of Federal Affairs at the Electronic Frontier Foundation, Sara Geoghegan, a legal fellow at the Electronic Privacy Information Center, and LaPerruque, Deputy Director of the Security and Surveillance Project at the Center for Democracy and Technology. Joining us virtually, we have Cynthia Conti-Cook, presenting in her personal capacity as a civil rights attorney and technology researcher, and Carmel, Shachar, Executive Director of the Petrie-Flom Center for Health Law Policy, Biotechnology, and Bioethics at Harvard Law School. Thanks so much for joining us today. So I'll start with our questions for you that we have today. The first question is, those who want to keep their reproductive decision-making processes private face a lot of challenges. A partial catalog of these challenges includes internet use, including searching and browsing, email and messaging, mobile phone use, including calls, texts, and location records, and specialized apps like period trackers, medical records, and financial records, such as credit card payments. Are there other items that you would add to that list, and are some likely to be more important than others?
Okay. So that's a pretty comprehensive list. So one of the things that we have been working on for a while is what would be the things that are the most at risk. And it's easy to go to period trackers because it has the word period in it. You know, the menstruation is what we're talking about, fertility is what we're talking about, but that's not actually the thing that's the biggest risk. The biggest risk to you is going to be anything that you post on social media, your browsing history, and your location data. You know, as we've talked about, this is a surveillance device. It lives in your pocket, it knows where you go, and the critical thing is it knows where you went a year ago, 2 years ago, 10 years ago, because the companies hold on to that data forever. Because why wouldn't they? There's no law that says they should not, and there's no penalty to them for holding on to it for an indeterminate period of time. So those are the things that are, and the same is true with your browsing history. The same is true with the unencrypted content of your messages. So while I would not recommend that you put on social media or any of your fertility or menstrual trackers, I had an abortion today, especially if you live in a location where that is not a legal act. Those are not, the period tracker, the menstrual trackers are not the things to be the most concerned about. It's your browsing history, especially in areas where it's not just targeting pregnant people themselves or people who could become pregnant, but it's also targeting the assist. What the people who are assisting people getting pregnant, if they're looking at any of that. So even if you yourself are not the pregnant person, if you're looking at something on behalf of somebody else, that could also implicate all of you. So it's not just constant vigilance for yourself, it's constant vigilance for everyone. And as the Congresswoman mentioned, that is exhausting. And that's not a very good way to live.
Yeah, I would agree with kind of a prioritization. I think the one type that I would add to what Cindy gives is communications metadata. It's not just the messages themselves, but the kind of the logs of who you call, email, or text, who you receive it from, when, if they're called, how long they go on for, location, browsing, communications, things like that. These are the puzzle pieces of your life. When each little bit, it can be very little, can not really real much of anything, or it could be any of 100 things. When you start to put them together and together and together, it can paint a shockingly, terrifyingly intimate picture. For something like location, if you're imagining someone moving around all the time and where your phone overlaps with someone else's phone, we were together for a extended time, it's easy to imagine that. I mean, something like communication, on the other hand, I just give an example. During the height of the Snowden NSA controversy about bulk collection of that type of data, there was a really good study that was done that showed kind of using just phone call logs, who called who, no content, no listening message, we're able to determine that someone had a heart condition, that someone was purchasing products, and that someone had an abortion. These are the things that those bits of data can be incredibly revealing. And yeah, I think we're probably all in pretty intense agreement that the sort of the idea of trying to regulate how much you put these various types of information out into the ether is just not something that can be put on individuals. A few years ago, we just probably that set out a warrant requirement generally to collect phone location data. There's some loopholes in that we're trying to solve now. But a big reason for the court's ruling on that, and just overall to create a warrant requirement, was, well, it's quite simply not reasonable for people to use a phone, and it's not feasible to say phones should function without putting out location data. It's how they operate. And the same way, a lot of the time, I mean, yes, I mean, there might be ways to try to keep your browsing history extremely private, to keep your chats extremely private, but by and large, it requires a huge amount of know-how and effort. And to be honest, there shouldn't be on the individuals, it should be on the law to show.
Excuse me, the folks in the back can't hear, so maybe the microphone's on, and just maybe if you could move on.
No little light on. Now there's a little light on. Okay.
So, sorry, while the people actually at the panel are figuring out the microphones, I'll take this time to cut in since I'm virtual. And I also want to emphasize that, oftentimes when we think of abortion and reproductive services, we think of medical data and we think of the heightened protections that come with medical data. The healthcare industry, because of HIPAA, because physicians are information fiduciaries often for their patients, does have a culture of being reluctant to share medical data. Not to say data breaches don't happen or inappropriate disclosures don't happen, but that it comes from a position of saying, okay, medical data should not be shared. But there's a whole host of data, as that laundry list you gave, that isn't strictly medical in nature, but is really probative of somebody's reproductive health status, of whether they're pregnant and don't want to be. And I think one thing as a health lawyer who deals with data privacy that I'm really struck by is that very often the technology industry does not have the same approach to
data sharing and data privacy that the healthcare industry does, because it's an industry that has been built on data as a commodity and data for sharing. And I think because of that, you really have to dial up your precautionary measures, as my co-panelists have said, and you have to try to approach, okay, I need to make reproductive choices for myself in a way that ideally would be pre-internet revolution. Now, I'm a millennial, so I solve every problem by immediately Googling on my phone how to solve that particular problem. So I know that it's easier said than done, but I tell everybody, if you could go back to 1972 and think about the women who unfortunately were facing, in a way, a similar legal climate when it came to abortion, how did they go about solving things as opposed to approaching it as somebody living in, 2022, the modern digital age?
Yeah, I can go back. I agree with everything that's been said so far. And I do think, can people in the back here? I don't know. No. Oh, man.
Now, okay, is that better?
Yeah.
Okay, so I agree with everything that's been said so far. And I do think something that is very harmful about all of these sets of data being used this way is that it really contradicts what we would expect. We do not expect that when we use an app or a map or just browse the web, that this data is going to be bought and sold to data brokers to target us with advertisements. And we know that there is kind of a loophole around the Fourth Amendment when law enforcement can access that data by purchasing it. So I think that this is especially harmful because this just is not what we expect to happen.
Thank you so much. Professor Conti-Cook, would you like to chime in on this question?
Sure, thank you. And thanks for the invitation. I'm speaking today in my personal capacity, although I'm not a professor anywhere this semester. You can call me Cynthia. I want to emphasize the importance of threat modeling in this atmosphere. It's really important, especially the long list Maya read off at the top of this question. It's really, you can feel the anxiety sort of build in your physical body as she's reading all of the ways that information is constantly being collected about us, and imagining the ways that it could be weaponized against us is really overwhelming. So I want to emphasize the importance of threat modeling, which is just a term that security operations sort of folks use to figure out what is the most threatening potential thing, and how do we know it's the most threatening, and how do we sort of focus our attention on that. And as I believe India said in the beginning, looking at some top priorities, looking at a few things rather than all the things. All of just because it might happen doesn't mean it will happen, and it doesn't serve us very well to try to fix all of things all at once. I would emphasize, and sort of, I think it might have been mentioned between Sara, Jake, and India, I'm pretty sure I heard, although there was a little bit of muffled sound, I'm not sure, but I think I heard someone say, even just normal messages. And what I want to emphasize is that when I do threat modeling, what I look for is what has already been introduced in court and how much emphasis has that been given. Think like a prosecutor, think like the investigator or the detective on this case. If they have the circumstantial type of evidence that shows some of the facts, but they're still missing that intent element, I like to think of it as like missing a gemstone for Thanos in his glove. Like, if you still don't have all of the stones, you're still not going to get the amount of juice that you want in your case to be able to force the plea or to be able to win that jury trial. And if you're thinking like a prosecutor in that way, or thinking like a detective in that way, you know that you need to have one of the most difficult elements in these types of cases, which is the mens rea, which is the intent. And that is the space that messages and keyword searches fill. And while I think other types of data is also very important, location data, et cetera, really what I would emphasize is that the types of data that is the most important to think really creatively about how to protect, both individually and on a policy level, are the things that capture the pieces of data we co-create, the things that come from our thoughts, the messages that we send to our loved ones, and the keywords that we search for in our browsers. And so that is what I would like to emphasize here. And I think that we actually have to go beyond our digital devices. I know that's what we're focused on, but even in how we think about who we share this with on a very analog level, how we think about who we share this information with, whether it's about reproductive health or whether it's about anything else, honestly, that you think might make you vulnerable. The circumstances that we're currently living in require us all to sort of do an operational security check on ourselves, our networks, and think about what we share with whom and why.
Thank you. Those are great answers all around. So the next question. Our next question is, what are the best practices tech companies should be taking to protect consumers' data privacy? How can people advocate for them to make those changes? And what measures are tech companies currently taking that meaningfully protect reproductive data privacy? Furthermore, what steps are they taking to protect content integrity and or combat misinformation around reproductive health services? Yeah. Are these measures effective? And if so, should the US or the tech companies themselves adopt or implement such measures?
Okay, so is this one on?
Yeah.
Cool. All right, so first of all, we have a whole thing on our website about what tech companies should do. The TLDR is they should do less. Collect less, gather less, keep less, store less. If they don't have the data, if Google or Apple or Candy Crush or any of the thousands of apps that are on your phone that want to collect your location data, if they don't keep it, when law enforcement comes to them and says, we want to know where everybody was on this particular day at this particular time, if they don't have it, then they can't turn it over. They don't have to fight a lengthy court process about whether or not they turn over data if they just don't have it. They need to encrypt more messages. End-to-end encryption means that, as Jake was saying, they may have access to who you texted or called and for how long, but they don't have access to the content of the message. So for example, the teen in Nebraska who was texting with her mom, oh my God, I got pregnant. If they had been using an encrypted message service, I'm pretty sure that teen texts with her mom frequently. I text with my mom frequently. So law enforcement, knowing that I text with my mom a shockingly large amount, is not going to give them anything that they can actually use in court if they don't have access to the content of the messages. But they were communicating over an unencrypted platform, which means Facebook, and therefore law enforcement had access to the content of the messages. So if law enforcement cannot get access to the data, they can't use it to prosecute you. If companies don't collect the data in the first place, if they don't collect data that they don't actually need to engage in the transaction with you, if they don't retain the data for longer than they actually need it to complete the transaction, then there's just less out there that can be weaponized. So encrypt more things, collect fewer things.
India, could you just tell everyone about the incident with the mother and the daughter who were chatting? I think some people have a level of familiarity and others may not.
Sorry, this has been huge news in my world. So if you, just to recap, there was a 17-year-old girl in Nebraska, and I'm using the word girl because she is 17, which means legally she is a minor, even though she's going to be tried as an adult. Under Nebraska state law, pre the Dobbs decision, it was illegal for her to obtain an abortion in the way at the time in which she did. So this prosecution was actually underway because one of her friends tipped off law enforcement that this particular individual had obtained an illegal abortion. So this prosecution was underway even before the Dobbs decision was handed down. And one of the things that they did was they sent a court order or legal order to Facebook and asked for the content of communications between this girl and I don't think it was just the girl and her mother, but the content of this young woman's communication. And so in the course of that, because Facebook kept the actual content, has access to the actual content of those messages, it was easy for law enforcement to understand what went on. So all that they're talking about in terms of mens rea and intent and all of this other stuff, it was clear to law enforcement that she didn't just have a miscarriage, that she intended to terminate her pregnancy because she said so in the messages. And her mother is being targeted as well because she was able to assist her daughter. And if that makes you feel a lot of feelings, know that you are not alone.
Thank you.
May I build off of that for a moment? Another really significant aspect of that case is that the information that the detectives got from Facebook then served as the foundation for a much larger request that the detectives sought for, I think if someone recalls exactly, I think a dozen or so devices from multiple people. And then with the devices, the prosecutors and the detectives could do a much more invasive download of not just the information that was being held by Facebook, but much, much more information that is going to be produced in a format that the detectives might be able to put in chronological order or in geographic location on a map or in a social network map or in other types of very digestible methods of viewing, of displaying, of analyzing. And so it's really important to note that it's not just the information they're gathering, it's the information they're gathering and then using as a foundation to do much more invasive searches, which are also, and digital forensics tools sort of haven't gotten much of the spotlight of many of the recent conversations, which have focused more on what tech companies can do, but digital forensics tools in the hands of police departments across the country, and other types of agencies and other types of non-government actors. These forensic tools are for sale and they are available to many more people. And it's important to know that it's not just a sort of governmental privacy from governmental actors, but privacy from all sorts of actors. These tools, once they are able to plug into a phone, currently there's no regulation on what they can take down, on how long they store information, and what that information, when stored for an inevitably long time, is used for. And so just want to throw in digital forensics as yet another thing to really keep our eye on.
And to add to that, part of the reason that law enforcement was able to do that so quickly in this particular case in Nebraska is because this is not new. It is new with abortion because the underlying legal landscape has changed. But we have been seeing law enforcement do this for other issues for a very long time. If you've been working at all with the immigrant rights movement, if you've been working with protest movement, some environmental things, there has been a lot of movement for law enforcement to try to get access to this data. So the whole process by which law enforcement goes after companies to get the content that they're looking for and the way that the companies respond to those orders is all pretty established because they've been doing it for a very long time. It's just new with abortion because of Dobbs. It is not new in the world.
And the mechanisms are all in place.
And the mechanisms are all in place and they work, which sucks.
Do we have any other panelists who'd like to respond to this question?
I think I definitely emphasize the exact same points that you did. You can't turn over what you don't have collected or stored, or that you have only in encrypted form that is basically unreadable. I think one other thing companies will probably want to be thinking about in the future is where the data that they do maintain for a person, where they store it. So just in the past couple of weeks, California passed a new law that essentially says companies are not allowed to turn over companies in California cannot turn over information for an abortion investigation. Like typically what the main response was in that Nebraska case that he mentioned was, well, hey, we really do not have a choice in this matter. We have a order from a court. We are legally bound to do this. It does not matter what we want to do. We do not have a choice in this. We now have a law on the other side in California saying you just as legally strongly are bound that you cannot turn over this information. Now that law, it applies only to companies that are based in California and to handing over information in California. What does it mean to hand over a bunch of code or someone's email? It's ambiguous, but probably a better way to strengthen your hand to say this California law binds me and my hands are tied here is to store your users' data there. Now, California is the first state to pass that law. I very much doubt they will be the last. And as we get more and more states that become sort of data havens for reproductive health data information, I think companies would do very well to consider putting them in places where that data is more likely to be secure.
I definitely agree. I'm not sure that this mic, I think it's dying every couple seconds, so sorry if it goes out. I completely agree with everything that's been said. I think New York is passing a similar safe harbor law with respect to law enforcement investigations. And the only thing I would add is that I think the same data minimization standards that have been discussed should also apply to vendors, service providers, and other third parties with which tech companies share our data.
Thank you so much for those answers. So our next question is regarding law enforcement. So many may worry about protecting their privacy from public authorities, police, and prosecutors. However, in at least 3 states, laws provide that private individuals can sue those who perform or aid abortions and collect what are in essence spouses. How do those laws and perhaps others change who should be worried about protecting your data privacy?
Well, the laws, everybody should be worried about that. I mean, there was an issue in California where it turns out AT&T was selling location data to anybody with $300. And so that meant bounty hunters, that meant anybody who had money. PFF actually brought a class action lawsuit on behalf of AT&T customers saying that this violated their privacy, and the whole case got thrown out because of an arbitration clause that all AT&T customers had signed when they signed for their wireless contract. So unfortunately, we were not able to proceed with that particular case. So when you're looking at states that do have the support laws, I'm sure you've seen it. I know that I've seen it with my circle of friends, people who believe that Facebook or Instagram is listening to you because, you talk about something with your friends and then you see ads related to that. They don't actually have to listen to the words that are coming out of your mouth. They know who you share an IP address with. They know who you share Wi-Fi with. I landed in DC last night to do this, and I'm scrolling through Instagram, and all of a sudden I start seeing water filter ads on my Instagram because now I'm in DC and apparently you still have a water issue, even though that's been going on for like 20 years. So Brita filter ads show up in DC because I'm now using DC Wi-Fi as opposed to San Francisco Wi-Fi. Facebook knows where I am. My Wi-Fi knows where I am. T-Mobile knows where I am. And they know who I'm sharing things with. And if you share space with somebody that you care about, who could become pregnant, not only you, but also the person that you care about are at risk. Now, it was actually interesting. I was at DEF CON about a month ago, which is a hacker summer conference in Vegas, where very talented, very brilliant engineers go and they know a whole bunch of things that I can't even begin to contemplate. But one of the things that they were really talking about is this idea of spoofing your searching. So like everybody pulls out their phones all at the same time and starts searching for medical abortions. Like we all do it right now in this room. So then if anybody later needs to go do a similar Google search, you've sort of created all of this noise around the search history. So your search history is crowded with all of these completely irrelevant things. Whether or not you could ever become pregnant, you start just making random Google searches for various things so that your search history is not as targeted or as specific. And so they were talking about this as a very targeted strategy to try to create noise around the search history to make the data less valuable to law enforcement. And there was a legitimate discussion about whether or not we should try to push this as an idea out into the world and do like campaigns around it. Like everybody on this college campus at this time, we're all going to search for medical abortions. We're all going to Google search this particular thing. And, from a policy perspective, I don't know that I love that idea, but from a engineering perspective, I can see why they would find that particular idea attractive. If you never search for anything, and then all of a sudden you do a whole bunch of targeted searches, and law enforcement goes and gets access to your data, gets access to your other devices, and finds a lot more information there about you, that's a very different story than if there's just a lot of static and then something that's targeted. So again, I don't know how I feel about that, but I know that that's an idea that's being discussed.
I think one important piece of a lot of these cases and the Nebraska case that we were talking about is that oftentimes these start with someone tipping off law enforcement. And I think that that was something I didn't fully grasp until the Dobbs decision, that a lot of these laws really allow for that. And thinking like a prosecutor, as we were talking about earlier, that's a good place for them to start an investigation. So who I'm thinking about, or to start to get a warrant or a subpoena. So what I'm thinking about is obviously abortion patients, those aiding and abetting abortion, and providers. But we should be thinking about who else has this information that's maybe in our lives, because that is unfortunately where a lot of these cases are starting too.
I'd like to invite other of our virtual panelists to chime in on this question.
Yeah, I would emphasize to check out the work of the National Advocates for Pregnant Women, of If, When, and How, and many other organizations across the country that have done a fantastic job. If, When, and How just recently released a report that demonstrated that a great deal of reports come from medical staff, family members, and friends. And so it's a really important aspect of this for us to sort of ground ourselves in, so that maybe we're not, concentrating as much on what could happen if all the period app data was in the hands of the most anti-choice politician or prosecutor, but really think about what has been happening, what is happening now, and what's most likely to happen in the future is the thing that we really need to focus on the most.
So for our next question, I'm going to ask, how does your work address the racial disparities in both reproductive health and state surveillance? So as we know, post-Dobbs, low-income people of color are most affected by the overturn of the abortion ban. I wonder if I could ask Cynthia to kick us off with this question, because I know that her work often foregrounds race.
Yes, as someone was describing earlier in the panel, how we have to sort of think about what we share and how we share differently. What I thought about was how for ages, people who have used EBT cards in order to access basic groceries have already sort of been doing that thinking, have already accustomed themselves to understanding the amount of surveillance that they live in. And of course, those experiences are most often experienced by people who have been historically oppressed in this country, which is unfortunately most often Black and Brown and Indigenous communities. And so when we sort of are thinking about the adjustments we all have to make in our psyche to this new sort of dynamic that we have with our digital devices, we can already look to the experiences that people that are on probation and parole, for example, have with just leaving the house. That they, especially if you look at the work of Media Justice, which has been really excellent at documenting the way that electronic monitoring impacts the way people just think about their day-to-day lives, sometimes even within their house, how they move. That is the experience that is already happened, that is already happening, that has already happened. And so when I think about the work that I do in sort of trying to understand how these combined trends are going to coalesce in the next few years, I really just, I don't forecast. I'm looking at what has already happened, and the places where that has already happened has been into Black, Brown, and Indigenous communities in the United States. We can also look to other countries. So for example, there was a fantastic report that I will have to sort of find really quickly. It's up on my browser, but I'm blanking on the name. I'm just back from vacation and regaining my brain cells. But there's a report that went to Egypt, Lebanon, and one other country and found the ways that surveillance tools were being used to target people belonging to LGBTQ communities for everything from like indecency to other types of like public nuisance laws. And we can look to what's already happened in historically oppressed communities in the US and what's happening in other countries to historically oppressed communities there to see sort of the path that we're walking down.
Thank you. Do we have any other panelists who would like to respond to this question?
I mean, one of the big ones is we need legislation. We need to change the rules. You change the rules, you change the underlying structure, you change the system, and it protects everybody in the system, especially the people that are the most vulnerable. And that's the critical piece. You know, Cynthia was talking about threat modeling, and we do something at EFF called the Surveillance Self-Defense Guide. And the one that we have for abortion and abortion providers is shockingly similar, if not identical, to the same things that we have been publishing about people doing work on the Southwest border. And if you're doing reporting, if you're doing working with immigrants, all of that stuff, it's all the same thing. But again, asking somebody at an incredibly stressful time in their life to download an additional app on their phone to make sure that all of their messages are encrypted, to make sure that you're not Google searching on your own computer, that you're going somewhere else, that you leave your phone at home, that you don't take an Uber, that you don't do any of these things, that your first step has to be, how do I protect my privacy? Not how do I deal with this incredibly stressful situation? Like, that's just not where we should be. And expecting people to behave perfectly all the time or risk prosecution is not a good system. The system has to change. And as Director of Federal Affairs at EFF, I lobby for that.
Yeah, one thing that I also want to say is that what strikes me is the point that at a really stressful point in your life, you're unlikely to be like, yes, what I want to do is download a new browser and figure out how to install it. But that also people's networks are different. And so as somebody who sits down the hall from like the Berkman Klein Center for Internet and Society and has friends there, I feel confident that I would be able to access that information in that really difficult point in my life. But there are a lot of communities where those networks aren't as accessible. And so I think really the idea of saying, you know, in America, we love to push solutions onto the individual, like, oh, you don't have childcare. Well, like, clearly you haven't like worked hard enough to find your own private solution with like daycares and nannies, or like, oh, you like don't have access to healthcare. Well, why don't you have a job that offers good health insurance? And throwing this on like the heap of social problems that we say, well, the individual should be able to solve it with enough bootstrapping and with enough know-how and relying on their network of friends and family. It's just not feasible. It's going to be a problem again and again. And I think really discussing, okay, where are the points where legislation and regulation could be successful? Because you know, there's been stuff passed in the House, but the Senate is unlikely to pass a data privacy bill specifically protecting abortion data, right? Like that's kind of a tough political sell. So thinking, okay, there's the ideal and then there's the politically feasible, and how many politically feasible tools can we put out there to help tip the balance?
It's only politically infeasible right now. We have
Yes. I love it. Glass half full. Absolutely.
So I have two more questions and then we'll transition to audience questions. So what are the best practices? Oh, sorry. So what should students do if they're interested in working in a field like yours? And how can students best prepare themselves to enter this field?
I've actually spoken with a lot of law students in the past few months since the Dobbs leak and the Dobbs decision. My advice is to read as much as you can and to write as much as you can. There's a lot of opportunities that are outside of the traditional law firm path that are very exciting and very rewarding. And I hope you all look into working at whether it's nonprofit or government work, or a lot of opportunities to advocate for people outside of the traditional law firm.
And let me just jump in and say that one of our students who was a co-founder of ethical tech at GW went off to work at the Electronic Privacy Information Center.
Yeah, Chris, my friend.
With your friend Chris.
I am perhaps not the best person to answer this question because I am not an attorney. I wanted to do policy work since I was a child. And so I moved to DC after I graduated from undergraduate without a job or an apartment and slept on someone's couch and shopped my resume around the hill until I got the entry-level job on Capitol Hill. And so I was there for 10 years before I left I burned out and went west. And so now I'm still doing the same work at EFF, but it's really hard to try to go to law school when you make no money on Capitol Hill. So I never actually managed to go. I intended to go to law school, never quite made it. You work really long hours on the Hill, but you learn a lot of things and you do really good work. And so just to echo Sarah's point, there's a lot of non-law firm ways to get there. EFF does a lot of really great work. There's a lot of other nonprofits that are doing great work. And actually, talking about California, since California has this lovely privacy law that they're still trying to staff up, there are opportunities both in the state government and in corporations that pay you actual salaries to focus on their privacy practices to make sure that they are actually compliant with California's law. So the more we can pass privacy laws, the more jobs there are for lawyers focusing on privacy.
So I want to give advice that I think is similar in some ways to the advice that was just given, which is I encourage students to not think about their first job out of law school or out of college as like, okay, this is where I end up, because that's a lot of pressure to land the dream job like straight out of whatever school or training you've had. But to think about it as maybe closer to the medical school model, where you graduate from medical school and then you go into a residency program, which frankly, your quality of life sucks and it's not exactly what you want to do, but it provides the training to give you the platform to do. And not to say that you should pursue opportunities that make your life awful for several years, because mental health is also important, but that you should think, okay, what training do I need to be a truly effective advocate in whatever area I care about, be it access to healthcare, be it data privacy. And so, for example, I worked at a law firm for several years out of law school because I was very interested in healthcare and access to healthcare. And I felt like I needed to see the business of healthcare and why things are run a certain way. And working at that firm gave me that insight and gave me that connections to then be an effective healthcare advocate in the future, which was my ultimate goal as opposed to working at a law firm. So think about it as very big picture and long game, because your career will hopefully span decades. And you want to end up really happy with the overall arc and trajectory of your career. And you want to set yourself up for success that way.
Yeah, I mean, there are so many ways to be involved. I mean, there's nonprofits and advocacy organizations focused on legislation, focused on grassroots advocacy, focused on litigation, focused on research, and really kind of digging into kind of getting information from all kinds of avenues. I would say kind of, I think, find areas you are passionate about and then start to kind of comb those different ways to contribute, because there's so many of them. I mean, that's all even on just like the nonprofit and advocacy side. You guys are at the heart of the federal government, and there are lots of great ways, both in Congress and the judiciary and the executive, depending on the administration, to be involved in these causes in very valuable ways. And I think, they are all necessary and they are all very under-resourced perpetually. I think, we always need more smart and devoted people in these fields. So I would just encourage, use every opportunity you can to find not only ways to contribute, but what is the right fit for you? What's going to drive you to want to work every day? Because I mean, you can be all in the same policy issue field, or kind of conversely. I mean, my office has like 3 separate projects devoted just to different avenues of digital privacy. So yeah, you can kind of be in the same policy field in very different ways. You can be doing different kinds of work, be it legislative, litigation, et cetera, in it. And you know, there might be a bunch of those that work for you, and there might be one that really drives you and helps you excel. So I would say, you know, not just looking for things like summer internships, but find externships, find research projects, find clinics that give you the ability to kind of maximize the different types of work you can do and find what feels like the best fit.
Thank you. So I want to make sure we have time to take some audience questions if there are any. So just raise your hand if you have a question and make sure to say if it's for a specific panelist.
I guess this is to everyone, but perhaps specifically to you, India. You mentioned the importance of legislation, and I think being in DC, we all think about like federal legislation and the Senate, like it doesn't do anything. So, you know, we can't really get anything done on the federal level. But a lot of these criminal laws are on the state level. So what can students be doing to help state efforts to combat these issues? And is there legislation that's attainable on the state level that we could be working on?
Yes. So yes, that is actually a really great point. So the question is, you know, working for the federal government, is that the only game in town? And the answer is a resounding no. It is definitely not the only game in town. California has an incredibly active legislature, and they're not the only one. New York is also incredibly active. Virginia, just on the other side of the river, which might as well be another country, but it's there. They also have an incredibly active legislator that are really doing a lot of things focused on privacy. And you know, like I mentioned, not only does California continue to work on their privacy law, they have an entire agency set up on regulating the privacy law that they already passed. And other states are looking at California as a model on how to do that. Talking about criminal laws, we think, you know, especially being in DC, we think of Congress as being the biggest pond, the biggest fish. And of course they are, it's the federal government, but we do have a federalism system. And so a lot of the laws that actually impact people's day-to-day lives are happening at the state and local levels. When you know, Congress is a 30,000 foot thing. And then as you start drilling down further and further, there are some really interesting things that are happening at state levels. You know, we're not talking about this as a particular issue, but one of the other things that Jake and I both work on has to do with facial recognition technology and biometric scanning, and what, if any, access should law enforcement have to those tools. At EFF, we think zero, none. We think it's an invasive search and you should not be able to do that. And fortunately, at some city levels in California and in Massachusetts and in other places, the communities agree with us, and they have passed bans against facial recognition technology used by law enforcement at the city level. So you're not allowed to use it in this particular city, which is a huge step forward for individual privacy. And those are things that are happening at the very niche level. I mean, we talk about voter turnout for presidential elections. We talk about it for Senate. There's a big thing coming up in November. I don't know if you've heard, but when you actually look at how turnout matters for the small lower down races, a lot of people will vote for president or senators and skip the rest of the ballot. And so the determination of who is in office and how do they do their work is really determined by a very small number of people. So if you're looking at actually making a difference in people's lives, you should definitely get involved at the lowest possible level. Local government is its own very special thing, but there's a lot of change to be made at that level, not just at the federal government level. If you're going to do federal government work, it's incredibly rewarding, but you got to strap in for the long haul. The lower down you go in terms of the hierarchy, the faster things move.
And to kind of add on that, I mean, you know, if folks kind of are sold on that pitch of how important it is, and I think, yeah, I mean, just very much those quite often just the states are where the policies and actions at, but don't want to kind of hammer down into one state, even one as big as California, being obviously many others they're not nearly that big. A lot of policy work is focused on national campaigns for pushing policies that, you know, be it because of federalism issues or political realities, only happen at the state level, and are looking to try to, you know, let us see if we can get a bill passed in 5, 10, 30 states. Conversely, because of the fact that, like I was just saying, the process can be very chaotic and very quick. Bad laws very often pop up like weeds. You know, those types of, in the same way you're trying to have nationwide campaigns, you have to quite often have very rapid campaigns to stop very bad things from happening all over the place all at once. So yeah, I mean, there are just a lot of areas where whether you want to focus on one particular place or whether you want to kind of try to take a comprehensive look, it's an incredibly important area of policymaking.
Thank you so much. If we don't have any other audience questions, I think I'm gonna invite Professor Bronick up to give closing.
Okay. Thank you. This has been an incredibly rich discussion about an important and timely set of issues. It's a set of issues that can be very scary, right? Because it concerns a new set of risks and dangers about very basic decisions and actions about reproduction and reproductive health. However, we've also heard discussion about actions that individuals can take to protect themselves, and more importantly, actions that data and social media and communications platforms can take, and potential forms of legislation and regulation at many levels, right? At the federal level, but also at state and local levels. So there are problems, but there are solutions, and there are roles for all of us to be creative about these solutions and to work on them. So in closing, I think the rest of my closing is just about thanks, about gratitude to folks here at the law school, to Dean Dana Bowen Matthew, to my co-director of the Ethical Tech Initiative, Professor Dawn Nunziato, to a number of students who've worked on this, Devin Sullivan, who's back here operating the camera, Ali Shield, who's providing social media support, Matthew Plotnick, who's been doing some setup, to our great speakers, to our staff, Amr Khan on the media staff, and Deborah Gales on the event staff, who've been very important in this setup, to our speakers, right, including Congresswoman Sara Jacobs, our panelists, Cynthia Conti-Cook, Sara Geoghegan, Jake LaPerruque, India McKinney, Carmel Shachar, and last but most importantly, Maya Arigala, a 3L student here at GW Law, moderator and chief organizer of this entire conference. So thank you so much all for attending. Good night to all of you who are online. And to those of you who are here in person, I welcome you to continue this with a reception that includes food right behind that glass that can be opened up. So thanks so much and have a good evening.